as Lisa. Who's that?
A paralegal.
All right, welcome paralegal. What's Lisa's last name?
Lee, L-E-E.
All right, Ms. Lee. Good morning, Ms. Lee. As Lisa. Who's that?
Good morning.
All right, welcome paralegal. What's Lisa's last name? All right, that would be the YouTube live feed that's going. Always tape delayed so I can hit the red button if one of you says something inappropriate. All right. So we've got everyone we need to have the conversation we're going to have. I don't see a court reporter, which is fine. That was on you all. So this won't be taken down. Let me describe what I understand the scenario to be, and then I'll let both sides say, well, actually, it's a little different than that. And then we'll get into it. Mr. Roberts brought this action on behalf of Mr. Bridges and a bunch of LLCs seeking declaratory judgment and injunctive relief against the landlord, which is 585 North Avenue, LLLP. I'm going to say effectively Mr. Holder. I'm not making it personal, but it's just easier to say Holder. Relief in saying effectively, we don't have to pay rent, although it doesn't sound like any of these tenants have been paying rent for many months anyway, but going forward, we don't have to pay rent. Maybe looking backwards a few months, we didn't, because of the language in the lease concerning destruction of premises. It's paragraph 14. I'm not going to dive into the language. That's what you lawyers will do. But the argument, as I understand it, is effectively COVID has it has constructively destroyed the properties, made them unusable to the tenants, and so they didn't have to pay rent, and certainly they don't have to pay rent going forward. Would be the thrust of Mr. Roberts' creative argument. Defendant disagrees with that and has effectively countersued. There's not a separate action, but there are now, as I understand it, efforts that defendant has undertaken seeking to evict the tenants for non-payment of rent. And we'll walk through whether all the requisite procedural steps have been taken, because they're fairly specific, the things that need to happen in order for a dispossessory, a writ of dispossession to be entered. But I think that's it. I mean, I think there's a little bit more to the counterclaims, but where we are is effectively Mr. Roberts arguing we don't need to pay rent. And I don't know if you're adding also, Mr. Roberts, we ought to still be able to use these unusable facilities, but at a minimum, we don't owe rent. And defense saying, well, of course you do. There's been no physical destruction. And by the way, because you haven't paid rent, you're out. It would help me as you expand upon that description, Mr. Roberts, if you'd also let me know if any of your clients presently occupy, like if I went and knocked on the door of 595 North Avenue, would someone with a cup of coffee answer the door and say, what are you doing? Or are these just businesses or what? So tell me if you agree what you would add as to where we are structurally, and then tell me what, if anything, is happening at any of these addresses.
All right, that is correct. One address, if you knocked on the door, someone would answer because it's an office and somewhat of a residential space and filing and a meeting room that's still being used. And my client was paying partial rent for the amount for the part of the structure that was usable. Okay.
How many different, there's 585, 595, there's a 611 listed. How many buildings or structures are we talking about?
3 structures, but they're all joined.
Okay. So one big building that has 3 addresses.
Correct.
Okay. I just noticed that Mr. Bridges had been in the waiting room. He's here. He's somehow on here twice, but I can see the top of his head and a ceiling fan. And then there's also just a phone number ending in 3462. Who is that? All right. I will move that person to a breakout room until someone can tell me who that. Oh, 3462, you are. All right, back in the waiting room.
The 3462, that's Neil Bridges also.
Okay.
I think
3
he's on.
buildings, 3 tiles. Let's add them back in. Okay. Mr. Aldridge, do you want to add anything more? Again, we're not getting into the substance of the dispute, but I just want to make sure I'm kind of understanding what the argument is here. You're on mute.
How about now?
Much better.
All right. So without getting into the substance, we did file a counterclaim for writ of possession, past rent owed, and then obviously we filed a response to the declaratory judgment action as well. So the only point of clarification is I understand Mr. Roberts' argument to be not that COVID has effectively destroyed the premises, but rather that the executive orders resulting from COVID have effectively destroyed the premises. But I think that's the only point of clarification that I would have just moving forward. And if I've got some confusion on that, I'm more than happy to be corrected on that point.
Well, Mr. Roberts is going to get an opportunity in just a moment to let all of us know his arguments in support of the relief he's seeking. So I'm not quite sure what folks were hoping would happen today. I don't know if this was in the attorney's minds, the hearing on the declaratory judgment action, or if this is a little early for that because it's a relatively new lawsuit and we're dealing with the dispossessory piece. I'm happy to work through any and all of it. Mr. Roberts, what was your sense of what we were doing today?
I thought it was more like a status hearing, or where we are with the case.
Okay.
I didn't think the merits of it was going to be heard today.
Okay, Mr. Aldridge.
Your Honor, we filed the request for hearing in this case, and in that request for hearing, we requested a hearing on the merits of the declaratory judgment action because it's solely a matter of contractual interpretation. So we're submitting that to the court for a hearing on the merits. And then also more than 14 days have passed per the argument set forth in our application for writ of possession. And so we believe that we're entitled to an immediate writ of possession because of the failure to pay rents into the registry of court as required by statute. And so we requested a hearing on those two matters, I think at the end of September.
Okay, I'm just pulling up the docket now. I'm sure that's in there. I just want to make sure I've got my fingers on all these different things. Mr. Roberts, while I'm waiting for this to come up, you mentioned that if I did knock on one of these doors, someone would answer. Is the structure or the structures, they occupied 24/7, or they are occupied when whatever business or businesses we're talking about are open for business?
During the day, it's occupied as a business, and they may meet potential customers. And when special events are held, all the buildings are occupied. There may be 2 events going on at once, or 1 event taking up all 3 spaces.
Is that what it's effectively an event space?
Correct.
And what type of event? Would you have a
Parties,
concert there, or a party, or a wedding?
boxing, martial arts, wedding, homecoming party, wedding reception.
It's a multi-purpose facility, so you could have a cage match and then clean the place out and have a homecoming party right after that.
Yep, our funeral.
All right. Okay. Well, Mr. Roberts, why don't you articulate, if you want beyond your pleadings, I've got your pleadings, so I understand that the gist of it, the reason why you think I ought to issue a declaratory judgment that, and or injunctive relief as to why either past rent is not due, or future rent is not owed.
I'm not saying future rent isn't owed. I'm just saying, he should, the plaintiff should only be required to pay rent for the portion of the facility that's usable.
Okay.
I mean,
Well,
he can't do any business right now in Georgia, except for, the office he uses and to meet with customers about future events, which we don't know how far in the future they're going to be.
why is it that Mr. Bridges can do no business?
Because the state ordered that clubs and event centers had to be closed during, I think came out in March.
So, I don't follow them religiously, but I know there have been ebbs and flows in the restrictions. You can go to a restaurant now, bars are open. When I was taking my son to baseball practice this weekend, the bars were packed because of the Alabama-Georgia game. So there were event spaces, bars that were really, really hopping. Tell me why or how your client's space is different. If he had wanted to have an Alabama, Georgia event that might have started out more like a homecoming and ended up more like a martial arts thing, but people were there, why couldn't he have done that this past weekend?
Currently, they're operating at 35% of occupancy per the health department.
So they could have events, but they'd be not allowing, the events wouldn't take full advantage of the scope of the space.
That is correct.
Okay. So it's not that Mr. Bridges can do no business, it's that business is limited.
And I believe he couldn't do any business April, May, June, July, I think August. And they allowed 10%. Okay, it's closed March, April, May, June, 10% in July. And now we're up to 35%. And that's in August, September, and where we are now.
So why wouldn't the argument be, if one subscribes to it, that no rent ought to have been paid March through June, but at least 10% of rent should have been paid in July, and then 35% of rent August onward?
No, the argument would be March, April, May, June. Partial rent should have been paid for the space he still could use as the office.
Okay.
The residential component, and the meeting facilities where he meets clients and meets about different things. And then going forward in June, that same amount for the main office facilities plus 10%.
Okay. So as the executive orders allowed your client to, in theory, reopen, he ought to be paying the commensurate increase in rent.
Correct. You said it better than I did. That's correct.
Okay. I'm just trying to understand it. Is it also correct that Mr. Bridges has, and I say Bridges, it could be the LLCs. I'm not suggesting he's personally liable.
No, that's fine. Yeah, no, go ahead.
Whoever's supposed to pay has actually paid $0 since March, even though you just acknowledged that really whatever percentage, if rent was $100 for everything, and the office space and the meeting space represented 10% of the overall space, then really Mr. Bridges ought to have been paying $10 a month because there was part of the space. But what I thought I read is that $0 have been paid since March.
No, he submitted partial rent March, April, May, and it was refused. I
Okay.
think June, yeah.
Okay, so there was a tender, but there was a concomitant refusal. It's all or nothing.
Correct.
Okay. So then do you agree with Mr. Aldridge was helping me recast the way I described what your claim is on behalf of your client? It's not COVID that caused the destruction, if you will, but in fact, the executive orders or administrative orders, whatever we're going to call them, that forbade your client from operating at normal capacity.
That's correct.
Okay. All right. And did you have any, it may be too soon for there to be COVID related case law, but there could be case law from past situations that may have occurred. Do you have case law you want me to consider beyond what is set forth in your pleadings?
No.
Okay.
I looked, it's just very unusual.
It is very unusual. We will see case law soon. It's probably too soon for it to have rippled its way through the appellate courts. Okay. Anything more you want to say in support of the deck action or the injunctive relief?
No, that's it.
Okay. We'll talk about the dispossessory piece separately, but also this morning. Mr. Aldridge, I've got your pleadings. First, is there anything you want to set forth factually, if you will, about what's been going on, and then share with me your arguments as to why this type of relief that Mr. Roberts is seeking on behalf of his clients is not appropriate?
Yes, Your Honor. First, I would like to address one point that you asked Mr. Roberts a point of clarification on. It's essentially that the contention was all or nothing on the rent. And without getting too far into the weeds as far as the discussions about the rent from April, May, June, July, there were ongoing negotiations regarding the rent owed. The parties were never able to reach a consensus regarding the terms of rent deferment or anything along those lines. And that was but I want to make it clear to the court that my client was certainly willing and open and actually approached Mr. Bridges regarding rent deferment and those sorts of things, recognizing the unique challenges that business owners like my client are facing during these unprecedented times.
And like Mr. Bridges is facing as well. So that's helpful to understand that there were some efforts to meet somewhere. They weren't successful, but it wasn't simply that Mr. Bridges said, look, I think I can pay this. And your client said, no, thank you.
That is correct.
All right.
And to address the substantive issue of the effect of the executive orders, we've heard very little insofar as how Mr. Bridges' businesses were actually shut down. I think the court recognizes that effective the beginning of May, in fact, it's May 12th, Governor Kemp began actively reopening the state of Georgia. Now, the state of business prior to that date was generally in the shelter-in-place order, where we were trying to figure out what we're going to do, what the best practices are. And then we got an order from Governor Kemp on May 12th, kind of setting forth the guidelines for that. And I believe that in reading that order, and then also in connection with the mayor of Atlanta's executive orders, these businesses would be categorized as non-critical infrastructure. I don't know whether they would be categorized as restaurants or if they would be solely categorized as banquet facilities or something like that. But I believe that they fall into the category of non-critical infrastructure. And on
I'm going to interrupt for 1 second. These properties are all within the city of Atlanta. So we do have that tension between what the city is doing and the state is doing.
That is correct, Your Honor.
Okay.
But I don't believe there's any tension insofar as the court's decision today, because regardless of which order we're seeking guidance from, Mr. Bridges ability to operate was never shut down. And insofar as the declaratory.
Let me stop you for a sec, because you said never shut down. I
Following-
thought what you just said was that until May 12th, everyone was shut down.
Insofar as the argument for the declaratory judgment, it's become mooted. But the court is correct that we've got about a month and a half period of time there where we're sheltering in place. But
Okay.
effective May 12th through the present, his ability to do business at these three properties has never been 100% shut down. Like all businesses, I'm sure it's been affected in some way by the social distancing mandates and those sorts of things, limiting the amount of people that can gather in one particular area. However, that is not the shelter in place orders are no longer in as great of an effect as they were previously. And so effective May 12th, 2020, this is no longer a declaratory judgment action. It's an action requesting that the court take some recognition of past events in order to set off some allegation of rent owed. That is the exact opposite of a declaratory judgment action because the issues have become moot. In regards to the percentage or pro rata argument, as far as Mr. Bridges being able to offset some portion of the rent based off of his capacity limitations, that's just something that business owners are having to live with. That's obviously not reflected in the contract. I'm unaware of any case law in Georgia or any other jurisdiction that allows for a after the fact redetermination of contractual rights, here specifically the contractual right to pay rent based off of some event having taken place that was completely outside the control of the parties. This isn't the sort of thing that falls in under an act of God defense. That defense is typically reserved to performance obligations that are non-monetary. In this situation, all of Mr. Bridges' obligations at issue in this case are monetary. He's alleging that his obligation to pay rent have been relieved in some portion. He's not alleging that he had any performance obligations that should be relieved due to an act of God defense. And so I really think that the act of God defense is really the only defense that really applies globally to the COVID-19 pandemic. But for the reasons I just stated, as this only being a monetary dispute, it doesn't affect this particular case. And so just to summarize my argument, effective May 12th, this converted from arguably a declaratory judgment action to a past damages set off argument. And so that for that reason, the declaratory judgment aspect of this has become mooted and should be denied by the court. And there are several reasons behind that we set forth in our brief. And if the court has any questions about those, I'm happy to address any of those questions.
What about the injunctive relief request?
The injunctive relief request, I believe, should be denied for two reasons. First of all, it's solely in connection. I believe it's 943, OCGA 943, and that's solely in connection with preserving the status quo while waiting for the court to issue an order on the declaratory judgment action. And because the declaratory judgment action is mooted, then any tag-along injunctive relief that would go along with that should be denied as well. So that's just in connection with the declaratory judgment action, which was the only part that was requested by Mr. Bridges. However, as to injunctions generally, an injunction is there to preserve the status quo. And what Mr. Bridges is requesting is the exact opposite of the preservation of the status quo. He's requesting that this court authorize and approve his non-payment of rent when he is under the status quo obligation to pay rent. And so he's asking this court to affirmatively change the status quo, enter affirmative judgments saying that he is entitled to hold back rent in some portion, which would be the exact opposite of preserving the status quo on an injunction. And so just based on that ground alone, any request for injunctive relief in general should also be denied.
Well, I guess there's the legal status quo and the factual status quo. The factual status quo is that Mr. Bridges and his businesses occupy these spaces, and they have for a while now. So maintaining the status quo would be keeping Mr. Bridges in the space as opposed to getting him out of the space. What the rent payments would be is a different question, but I think that it's a little more than just the status quo is he's supposed to be paying rent. That's what the contract said, but it doesn't sound like that's happened since March. So I'm not sure which status quo we're supposed to be thinking about, but I'll need to work through in my mind, as I understood you, Mr. Aldridge. The injunctive relief was effectively the bridge that maintains the status quo until the deck action could be ruled on. And your argument is there is nothing to rule on the declaratory judgment side because the businesses are open again. They may be limping along rather than moving at full throttle, but that is a business reality as opposed to something that a court needs to declare. Is that a fair recapitulation, or do you want to amend that?
That's fair, Your Honor. And when the court attempts to mold its decision on this, I would recommend that the court look to the case that we cited in our response to the declaratory judgment action, which is Pinkard v. Mendel. That's a Supreme Court of Georgia case. It is from 1960, but the facts are very close to this one. And so it was the closest in time case that I could find that was close to being on point. And in that case, the defendants filed a declaratory judgment action seeking injunctive relief to prevent an ouster from the premises, arguing that certain circumstances existed that I believe relieved their obligation to pay rent. And the court in that case said, look, the rights of the parties have already accrued, and therefore this isn't a declaratory judgment action anymore. If they want to raise this as a defense to the writ of possession, they're free to do so. But because this is no longer a declaratory judgment, and there should be no injunctive relief along with that request for declaratory judgment any longer.
Mr. Aldridge, there are 3 leases at play, one for each address, these adjacent addresses on North Avenue. Are they effectively identical in their legal language? There may be more rent due for a different address, but are they 3 pretty much carbon copy leases, or are there meaningful differences in the operative language?
I believe for purposes of what we're discussing here today, they're all carbon copies. I believe each of the destruction of premises clauses are identical. Each of the leases are triple net leases, and so the effect is, for purposes of our discussion, they're all identical. Okay.
And Mr. Roberts, in just a moment, I'll let you respond to what you just heard from Mr. Aldridge, but your client would make separate payments for each lease, or would he typically say, it's $100 a month for each of the 3 leases. Here's a check for $300.
I believe he would make separate payments for each lease.
Okay. And is there a significantly different amount owed each month for the different properties, or are they about the same?
They're close.
Okay. All right. So what are your thoughts about what you just heard from Mr. Aldridge?
I believe a deck action is proper. I mean, we're trying to determine the rights of the plaintiff in terms of, what percentage should be paid. Is it proper to pay that percentage? And what's the effect of the health department in the state of Georgia denying him the ability to operate and only use, the office portion, initially only the office portion of the premises?
Okay. Let's talk a little bit about the dispossessory action. I'm going to start with you, Mr. Aldridge. I don't know how much dispossessory work you do. I don't know that we've worked together all that often. I've worked some with Mr. Roberts in connection with dispossessory actions, which has educated me on the important procedural steps that are supposed to occur. And I'd like you to tell me if you feel that your client has complied with all of them, and if your client has not, what the consequence is. But before you answer those questions, what impact, if any, does the moratorium in magistrate court have on your ability to pursue this form of relief?
Your Honor, as to the magistrate court moratorium, I do not believe that any portion of this building can be categorized as a residence. I know Mr. Roberts may have alluded to that earlier. My client denies that. These are purely commercial buildings, regardless of anything that Mr. Bridges may have set up within the buildings. They're leased purely for commercial purposes, and therefore the moratorium doesn't apply in this particular case. There's no connection with the CARES Act or anything like that, and so therefore we don't have any connection with a prohibition on an eviction.
So someone might be living in there, but that might be against the way it's zoned, and regardless, these are commercial leases for commercial use of the three pieces of property as an event space.
Correct, and to our knowledge, they're only being used as an event space.
Okay, I'm not imputing it to anyone, but regardless of how they're being used, that would be a misuse. The lease is for an event space.
Correct.
Okay. And related offices. No one is suggesting that Mr. Bridges having an office or meeting space in there is a problem. Okay. Well, talk to me then about the steps you've taken to perfect the dispossessory action and where you think we are with that.
Well, service in this case was made upon Mr. Roberts as counsel for Mr. Bridges in each one of the entities by mailing a copy to him per the service statutes. I'm unaware of any rule in Georgia requiring any sort of personal service just because of a counterclaim for a dispossessory action. If the court's aware of that, that's something that I'm unaware of, and so that would be something that we would need to discuss if that's what the court's alluding to. But service in this case is through Mr. Roberts as attorney for each of these entities.
Okay. Mr. Roberts, did you receive service of the dispossessory action?
I received a copy of the answer and counterclaim. I don't believe it's proper to file for a dispossessory or writ of possession via counterclaim.
Meaning you don't like that it happened, or you think legally that can't be done?
I believe legally it can't be done. I mean,
the Georgia appellate
courts have repeatedly stated that the only legal means to remove in which a landlord can remove a tenant and his property is by the summary procedures found in OCGA 44750, which require you make a demand is refused, and then you have to get an affidavit signed by Superior Court, State Court, Magistrate Court, and then it's notarized. You can't really do all that in a counterclaim, and once it's served, it can be tax and mail or personal service. You have 7 days to respond. But under the Civil Practice Act, which governs DEC actions, there's no answer due to counterclaims. Everything is deemed denied.
So,
I'm sorry.
No, go ahead. Keep going.
And then with the dispossessor, if you file an answer, you guarantee the trial. You know, all the motion, summary judgment, all that stuff is out. You guarantee the trial, and it could be a jury trial. But as a counterclaim, there's no answer to file, and so the statute is not really applicable. And this being a special statutory action, the procedures of it govern over the general procedures of the Civil Practice Act.
And it was a specific counterclaim. The dispossessory action is a counterclaim as part of the answer that Mr. Aldridge filed.
That is correct.
Okay, so we've got an interesting intersection of Civil Practice Act and the specific pleading practice that is set forth in 44-750 and the following provisions.
Correct.
Okay, and what you're saying, Mr. Roberts, as I'm processing this, is you didn't get a demand. There hasn't been an affidavit, and if there was something that you could answer, you'd answer it, and then that would trigger a trial, possibly even a jury trial, which isn't anything we're going to be able to do anytime soon.
That is correct.
Okay, Mr. Aldridge, we're now down into the procedural weeds, but these are the kinds of flags that my staff attorney raised for me when looking through the pleadings thus far. What's your response to Mr. Roberts and his observations?
The response is twofold, Your Honor. First of all, in looking at the statutory language that Mr. Roberts just cited of 44-750, I don't believe it prescribes the only manner of filing an eviction. If you look through 44-750A, halfway through that subsection, it states that following demand, if the tenant refuses or fails to deliver possession when so demanded, the owner or agent, attorney at law, or attorney in fact of such owner may immediately go before the judge and effectively swear out a warrant or an affidavit for the possession of the premises. So I believe that permissive language there demonstrates that it's not the only way of making service of such a request for possession. The second is, if the court is wondering if a demand for possession was ever made, we delivered a demand for possession to Mr. Roberts on his client's behalf on August the 5th, the day after the suit was filed, and it demonstrated the shortcomings under the lease payment obligations that Mr. Bridges and his entities had made, and demanded possession of the premises on, and this is an August 5th letter. It demanded I'm going to have to find an actual copy of that letter because I don't think it's up on the system. So I can't recall off the top of my head the date that it was demanded.
But it was a while ago, and it sounds like there was a refusal or a failure to deliver possession, because here we are several months later. I want to work through with you your read of that sentence in 44-750. It does say may, but that's a term of empowerment. If X happens, then the owner may get the relief that is made available through the subsequent statutory provisions. If the tenant doesn't refuse, if the tenant says, all right, you got me, I can't pay, here are the keys, then of course you can't then go in front of a judge to say we need possession, because you got possession. But I guess I'm not reading it as this is just one. Why would these provisions be here if you could just go ahead and sue someone?
Well, I think the issue here is one of service. I think that's a question that the court has here, and I'm taking the position that service was made upon the attorney of this case, and that the means of service are not solely limited to the procedure set forth in 44-750 and the permissive language. I think I understand the court's interpretation of that, but I don't think there's anything in that statute that states this is the only means of alleging and then serving a dispossessory action. I believe that, I think it's 9-11-4 allows for service to take place in through other means. And admittedly, okay, I'm addressing this question a bit on the fly because I haven't considered it before. So if the court would like me to brief it out, the issue out a little bit more, I'm happy.
No, I'm not articulating my concern very well. I don't think it's a service issue. Mr. Roberts in a minute can say, no, it is, and here's why. But the next step, if there is a refusal to turn over the property, which there has been, is then for you to get an affidavit and get it to, and it can go to whatever type, it lists a variety of jurisdictions, one of which is Superior Court. Has the affidavit been provided? And that would then trigger me, since the case is in front of me, to get a summons so that the sheriff serves that personally upon the defendant. And I don't know that that step has happened, because then that triggers the rest of the events that Mr. Roberts was describing. Once that happens, 7 days to respond, et cetera. I was under the impression, perhaps mistaken, that that next step had not occurred. And I guess what I misinterpreted you to be saying, misunderstood you to be saying, Mr. Aldridge, is that because it says may in 44-750, all that affidavit stuff and get in front of the judge and et cetera, we don't have to do that. We can do it a different way, and that yet we can still get our dispossessory. And I'm not familiar with other ways of dispossessory actions proceeding, and more importantly, that writ of possession, that's what you want in the end, being issued absent compliance with the procedures set forth in 44-750 et sec. So that's where I need you to help me. If you think you are able, a landlord is able to operate outside of those provisions, skip some of those steps, and still get a judge, not a jury, although you don't get jury trials in magistrate court. So I'm not so sure about the jury piece, but I'm sure that Mr. Roberts can point me to that. But regardless of the trial part, there'd be a hearing. That's what happens in magistrate court all the time, are these dispossessory hearings. There'd be a hearing, but to get there, there are these very specific steps that need to happen. And I don't think they have, but I don't have all the information. So it's really a two-part question. Have they happened? And if not, do they need to? Because if the answer to the first one is no, and the answer to the second one is yes, there isn't any dispossessory conversation we need to have right now because it's not yet ripe. If you believe the answer is no to the second question, then we ought to keep going. Does that make sense?
I think I'm tracking. So to answer the first question, that none of the affidavit aspect of this has been dealt with. So jumping to the second question, it requires service. And so I think that I was jumping in front of the court here a little bit as well. And the service was made through mailing in response to the DEC action, a copy of the request for substantive relief to Mr. Roberts. I have not considered whether any of these other concerns that the court's raising, such as the affidavit, must be strictly adhered to. And so I would need a little bit of time to address those specific questions.
Okay. I don't mean to put anyone on the spot, and I apologize if I didn't make clear enough in advance what the focus was today. I had hoped we'd do what we're doing right now, which is get into the substance of much of this, because Mr. Bridges is obviously anxious to know, does he get to stay in this place? And Mr. Holder is anxious to know, if I got someone in there that's not paying, can I get him out so I can hope to fill the place with someone who would be more able to pay. So I appreciate the urgency and importance for both sides. Mr. Roberts, anything you want to say in response to the exchange that Mr. Aldridge and I just had?
Okay.
In particular, this notion that one can work through the provisions of the 44-7s, if you will. But as long as there's been some service, if you will, notice, and certainly you and your client, Mr. Roberts, are on notice that defendant is seeking to retake possession of the property it owns, then why couldn't we have a hearing about what ought to happen due to the non-payment of rent?
Because procedurally, the appellate courts have stated, only way a landlord can remove a tenant and his possessions from the property is through the summary procedure found in OCGA section 44750. And you can also look at Roberts v. Roberts, which is 205 Georgia App 371. All right, and also, a dispossession proceeding is a creature of statute and is accordingly subject to strict rules of construction. And it's thoroughly discussed in Skelton versus Hill at 175 Georgia App 144.
You're finding cases even older than the ones that Mr. Aldridge found.
Yeah, I mean, in terms of do a jury trial, you can look at Hill versus Levinson, 259 Georgia 395, and you're entitled to a jury trial, but not in magistrate court. But the court reasoned that because you have a de novo appeal from magistrate court, you still get your right to a jury trial, and there's no harm because you start anew. And in Hill versus Levinson, they discussed cases all the way back to the original ejectment action where the king ordered 12 good men to remove, someone from premises. So it goes back even further than that.
You're really going back. Something about the Magna Carta. All right. Well, my thought about this, Mr. Aldridge, is that I want to give you an opportunity to, and when I say brief, it can be an email that you send to Ms. Niles and to Mr. Roberts. It can be a letter brief. You can structure it however you want. My focus is here on nimbleness. The sooner you can get me information, the sooner I can act. But I'd like to give you a chance, Mr. Aldridge, to set forth the reasons, the legal reasons why you think a dispossessory action can occur procedurally outside the confines of 44750 and the subsequent provisions. I'm not saying it can't. I haven't seen it that way before. And to be frank, we don't see a lot of dispossessory actions. We see the appeals from them, and those usually end real quickly because the tenant is unable to put rent into the registry of the court, and the appeal is denied, and the writ of possession is reissued by the Superior Court judge. This is a different situation because there's not that lower court proceeding, and so I think it is starting de novo. But it's really, it's starting for the first time. It's not a do-over. It hasn't happened yet. So it may well be that there's no problem with a dispossessory action being a counterclaim. I don't think there is a problem with that. But I think once you utter the D word, dispossessory, that triggers the need to comply with 44750 onward. And I want to be clear, I was not ever hung up on, wait, you served Mr. Roberts? That wasn't the point. I think Mr. Roberts and Mr. Bridges were on notice that your client was seeking to reclaim his property or its property. It's a LLLP. It's a partnership. But that desire, though expressed, then needs to be pursued, I believe, in a certain manner. It's not clear to me that it has been. You may find case law or statutory provisions that say, well, no, if it's a counterclaim, or there are alternative means that guarantee to both sides the procedural due process that is provided for in 44750 at SEC. I just don't want us to get to an endpoint only to learn. I don't know that it would be learning, it would be being told from a higher court. You can't skip this stuff. The legislature set it forth for a reason. It is how you do dispossessory actions. So you tell me, Mr. Aldridge, how you'd like to respond and how much time you'd like, and I'll give Mr. Roberts the same amount of time concurrent. He's not going to need to respond, but if he wants to add more than the two cases he cited, he's free to do that. My default would be to be guided by the statutes, and I would need to see a case that says, even though it's a dispossessory action, it's okay that you skip steps or don't comply with steps because X. So that's where I am right now.
I think I understand. I can have a response to the court no later than the end of the week. Hopefully by the end of the day. I just need to do a little bit of research on these issues.
And I'm not trying to create busy work. It's just, like I said,
I understand.
Upon receiving the complaint, the petition, and the answer and counterclaims, two things, two little flags went up. One was, is this really a deck action kind of thing? And the other was, I don't feel like all the pieces of dispossessory are in place such that we could be at that final point to say, hey, you haven't paid rent. Unless you're going to real quickly put some serious rent into the registry of the court, I'd be issuing the writ of possession. Because, I mean, the numbers are there. There's $0 that have been paid. There's an explanation for some of the non-payment, and there's a disagreement as to how much partial payment ought to have been made. And I appreciate the fact that Mr. Holder and his partnership were even willing to engage on partial payment, because the airwaves are full of stories of landlords who say, you know, I feel your pain, but it's not my problem. I can get someone else in this piece of real estate who will be able to pay rent. So it's all or nothing. And certainly a landlord would be in his right to do that. But these are complicated times. And so I very much appreciate, as I trust Mr. Bridges did, that there was at least an effort to meet somewhere in the middle, even though it was an unsuccessful effort. So I'll give you till the end of the week. And I say that only because I want to give the same amount of time to both sides. And if you get it done earlier, you get it done earlier. That won't mean Mr. Roberts needs to get his done earlier. But by the end of the week, 5 o'clock on Friday, please share with me your thoughts and cases on either side about whether we are bound by the provisions of 44-750. And if the conclusion, Mr. Aldridge, after you review more, is that you are, then also set forth in what you provide where you think we are then in those provisions. If there needs to be a reset for you because there wasn't the personal service on the defendant, or you may find case law that says, look, you've already served the lawyer up front. A lot of these provisions are tailored for pro se tenants, and that's not what we've got here. We've got a different structure, but that I don't think means that we pull ourselves entirely out of the 44-750s. Was that clear enough, or do you have questions? I don't mean for you to have to spin your wheels, Mr. Aldridge.
Well, I have questions, but I think they're going to be answered through my research rather than us talking about this. So I think I got the general parameters of what the court's requesting.
Okay. I mean, it's really, they're my questions too, but it sounds like we have the same questions, and the project would be for you to try to answer them, because that will guide me towards, yep, that's what those cases say, or, you know, that's a creative reading of that case, but I disagree. And Mr. Roberts, you have the parallel opportunity on the other side, although I think you've already articulated why you think we ought to travel through the 44-750 channel. As far as the substantive pieces of the complaint or the petition in this case, the deck action and the injunctive relief, I feel like I've heard what I need to hear from both sides. And I think based on the pleadings and what we've heard today, I'm in a position to rule on those. That certainly doesn't make the case go away, regardless of how I rule, because of this particular counterclaim that we've been talking about. Mr. Roberts, was there anything more you wanted to share in connection with the request for declaratory judgment and or injunctive relief?
No.
Okay. Mr. Aldridge, anything more on those two pieces?
I don't think that we addressed my second argument, why it doesn't apply, and I'll be very, very brief here. I think just the plain contractual reading of the clauses only apply to a physical destruction of the premises. So even regardless of any argument that can be made that they apply concerning any executive orders, I think the plain reading is only a physical destruction of the premises that is capable of being repaired. In the event that it's not capable of being repaired, the lease terminates automatically. And so under no set of circumstances can any argument advanced by Mr. Roberts prevent the termination of the leases. And so really what we're arguing about here is, can my client repair the damage that has been done by Governor Kemp and Mayor Bottoms? And the answer to that is just no. It's the clauses are only in relation to physical damage that's capable of being repaired.
I'm reading that section 14 again. Okay, I hadn't thought about that second piece. I had very much picked up on and been thinking through, what does destruction mean? And typically we think of, a tree falls on it and that is repairable. I hadn't thought about the verb repair. And if the nature of the alleged or complained of destruction is irreparable, then either the lease automatically terminates and Mr. Bridges needs to go, or this paragraph doesn't really apply because it's not destruction. And Mr. Holder may be an extremely powerful individual, but he is unable on his own to overturn the executive orders that may have wrought some of the financial harm that Mr. Bridges has been feeling as a result of the pandemic. I appreciate you flagging that because that was part 2 of your argument. It was good for me to hear it. Mr. Roberts, anything you want to say in response to that?
No, I mean, I think the argument is spelled out in the deck action, and that's what we're kind of asking the court to decide.
Okay, got it. Well, I feel equipped to handle that. I'll feel more equipped on the dispossessory side after both sides have added whatever they want to add, no requirement to add anything. But what that does mean is that by the end of the week, I can turn to that piece as well and let you all know if I think it's time to issue a writ of possession, or if there are some steps that need to occur before we would get to that stage. And then you have a chance to respond to that. Mr. Roberts, anything else at this time on behalf of your clients?
Yes, I think Mr. Aldridge is going to reply by Friday. When do you want me to reply to his?
I want you to submit something if you choose to at the same time. I'm not viewing this as a reply and then response to that. This was a request for information. So it's a RFI from me because I am stuck, I think where you are right now, Mr. Roberts, in that I'm familiar with dispossessories proceeding through the statutory provisions you alluded to. And Mr. Aldridge is going to get a chance to explore whether what he's done complies, and if it doesn't, how to remedy that, or if in fact, regardless of the times we're in, or it's a counterclaim or this or that, there are indeed certain steps that must follow, the affidavit, et cetera. And it's after I get that from him and anything you might want to add, Mr. Roberts, at that same time. So it's, again, it's your window of opportunity to say, basically to cite to the cases you've already cited to, which is why you may not have a whole lot more to add, but I'm giving you that same opportunity. By the end of this week, send something to Mr. Aldridge and Ms. Niles. It can be an email, it can be 3 citations, it can be a letter brief. You can e-file something, however you want to do it. I'm not putting any requirements. I just would like to get the thoughts from both sides as to how confined we are to 44570, and if we are so confined, I'm sorry, 44750, where we are in the process. Okay. All right, Mr. Aldridge, anything else for your client?
Just a statement that for the court's reference, the counterclaim is verified. And so that may satisfy some of the affidavit requirements. I'll have to look into it further, but we do have a verification as to the facts supporting the request for possession.
Okay. I appreciate that. That may well be a way to get to that next step, if in fact we even need to get there.
Right.
Okay, great. Well, I appreciate everyone dialing in. Stay safe. I'll look for something by the end of the week from one or both sides, and we'll take it from there. If something comes up that needs our immediate attention, please, whether you e-file something or not, let Ms. Niles know. She is the most direct route to getting us back on the phone or on a Zoom call if there's something we need to work through.
Thank you, Your Honor.
All right, appreciate everyone's time. Bye-bye.
All right, thanks. Bye-bye.